I am doing this webinar on how to prepare for a successful mediation. I practice mainly family law, so it's going to be kind of in reference to a mediation that has to do with the dissolution. But this can also go, to other extents as well. This can, be mediation in other aspects as well. Let's see if I can get this. There we go. What kind of mindset should I enter mediation with? Well, that is a great question. So I think the first thing you need to recognize is, everyone goes in a little nervous. It feels like a lot of weight is up in the air, and that is okay. If you're working with an experienced attorney, you should be able to feel prepared, feel like they've done the hard work ahead of time, and that they're going in with a strong offer and, strong negotiation points and skills to get you where you want to be. One thing that I've heard over the years that I think is a really helpful kind of sentiment is that both parties should really ultimately leave slightly unhappy if we have a successful mediation. Why is that? That is because that means both sides were able to compromise in some way, right? If one side leaves completely super happy, got everything they wanted, we know that there was no compromise. So I think one of the mindsets you have to go into mediation with is knowing that, what are your strong sticking points that you're not going to compromise on? What are some of your potentially more lenient points you can compromise on? Because that's all part of how do we settle? How do we not go to court and come together to make a decision? Another part of this kind of mindset is be open with your mediator. It's not about convincing, but settling. So I think sometimes we feel the need to say, mediator, be on my side, like do what I want. Mediators do this all the time. They see often same stories, and they often have either been judges or been in those positions, and so likely knows what a judge is going to make. So I think being open with them, giving them the facts is really important. It's less about saying be on my side, but giving them the important facts to help them see your position. Lastly, I think it's very important when you sign, if you come to the end of mediation, you come to an agreement, you have to be able to live with yourself with that decision. You don't get to wake up the next morning and say, wait, I no longer agree with this, right? This has to be a decision that you can sit with, you can live with, and you can move on with your life with. So I think that's a good thing to think about when you're in mediation and negotiating, and having those conversations with your attorney up front is really helpful too, so they can know your position. What should I consider in regards to my real property? So if you want to have a successful mediation, there's a couple different things you can consider, right? Maybe you should be talking to a mortgage broker about options for keeping the home. So, if that is your really strong goal, is that you want to stay in the family home and you're going to somehow have to pay out your ex-spouse, is that feasible with your mortgage balance, with the rates, with the price of the home? Those are things, if you can get an expert to weigh in on, or even someone to say this is the reality of the situation, it's really helpful to go into mediation with that, because then you can have some concrete backing on your points. Appraisals often are very helpful, especially if you have multiple properties. If you and your spouse or partner can agree on a value of the home. An appraisal sometimes isn't necessary, but often appraisals can be helpful if we have, you know, a high value house, or even if we have a home that you know, is potentially, you know, online for a higher value, but you know it needs a new roof, you know it needs new floors, right? There's multiple potential updates that could maybe lower the value and your benefit. So that's something to look into. Um, I think something that comes up in mediation a lot is staying in the family home feasible? I think you have to consider this financially, and you have to consider this practically once you're divorced, right? Is living in a 5-bedroom house by yourself 50% of the time makes sense? Are you able to refinance to get your ex's name off the loan? Um, you know, a lot of people have attachment to their family home and have a very sentimental value to their family home, which is fair and valid, but you have to consider if in the next couple of years staying in that house will be practical. So I think knowing the answers to those questions before you go into mediation will really help you have a solid stance on kind of the outcome you seek. So next is, what is a property settlement worksheet? Great question. So in not a lot, in all of our dissolution cases, when there is property involved and we're looking to split it, we create a property settlement spreadsheet. This essentially shows community property, and then we can divide it out to get to a number we're looking for. So I made a little example. I apologize if it's hard to see, but you can see this is a Jane Doe dissolution. We have a date of marriage, date of separation, and you know, I've just filled in some fake numbers here, but so we can kind of look at this. So we have real property, right? We have the home, the mortgage balance, say it's being awarded to husband here. You know, we have some bank accounts being awarded to wife, some to husband. We see this fidelity one. Husband has a little bit of separate value in there. Likely that's because after your date of separation, if you're still earning money in a retirement account, that can be categorized potentially as separate property. But like we see here in this division of the fidelity account, it's divided 200 to wife, 174 to husband. We see some significant debts here that are divided. But at the bottom, we see equalizing cash payment, 500,000 to a wife, negative 500 to husband. And we come out to a 50-50 division. One great thing to consider, I think a lot of people come into the dissolution process thinking that you know, everything's going to be split 50-50, which is definitely not the case. There's a lot of factors to consider, including income, including asset allocation, and health, job status, a lot of different things, right? But so this is, I think, helpful just to show is a great visual way to kind of see how we can play with the asset division and how we can get really creative, right? It doesn't need to be that everyone gets their own thing and then we try to get to a number, right? We can give one party an entire account, divide some of an account, right? We can do a cash equalizing payment. We can, you know, in this scenario, they could sell the house, which would liquidate a lot of assets. Separate property, while it's typically divided to the person who owns it, it can be considered in your division. So if one party has a significant amount of separate property, that can be a consideration, so keep that in mind. A lot of the times when we're doing mediation, we can look at what person is getting a significant amount of liquid assets versus, you know, say retirement assets that they can't quickly access, right? So there may be an argument to, you know, maybe someone's giving a little less of a percentage because they're getting more liquid than the other person is getting mainly retirement assets. So this is just a nice way to visualize and think about how you can really, really get creative and divide your assets in this way. Unvested stock options. I put this in here because in a lot of my mediations recently, it has been very, very important. So if you work for a company that you are getting stock and they're vesting over a period of time, and then you separate from your spouse, some portion of that stock after your separation can potentially be community property. I think this is a really frustrating realization for some people because, you know, you could potentially not even have access to that stock yet. The value could change. And, someone's telling you that your partner who you are now separating from is getting some portion of that. So, I highly recommend a financial analysis of these kind of assets, having an expert come in and kind of give their opinion on where they think the division lands. There's ample case law around this issue, and I know it pretty well. But having an expert's opinion and a report written up really gives you a strong stance in mediation to say, this is the actual division of these assets and they shouldn't be messed with, because you will have opposing parties or opposing counsel who, will oftentimes try to, say they deserve or they should get a larger division of these kind of assets than the law actually calls for. So having an expert's opinion on this is really, really helpful. Also just something to consider. A lot of the times these are things that people don't want to divide, because you're kind of running potentially a risk of, say you divide some portion of this to your ex-spouse and the value could go significantly up and they're getting, a larger chunk than was anticipated, or it could go significantly down. So you're kind of gambling on that a little bit. So that's something to consider if you're seeking to divide those kind of unvested stock options. How can I be creative? I think a big part of mediation and getting a successful, having a successful settlement is, how can we divide our assets in a creative way, right? What can we do? Maybe there's potentially a payment plan, or maybe we throw in some spousal support, or maybe, a vehicle is paid off, or, there's some kind of cash equalizing payment from somewhere, right? You can get really creative and different things will entice different people. So I think being prepared to have different offers, have a strong starting offer, and then know kind of where you're going to go from that, and know what your low base is, or like the number you will not go beyond. I think those are all really important. And then how can we even manipulate the numbers that you have even in your original offer to be more creative and make this offer more enticing for the other side? I think you can, as a client or as a person going through mediation, you can really help your attorney understand the other side. What would be more enticing to them, right? What could potentially get a settlement easier. Maybe you don't want to give them that, right? But being able to understand that and let your attorney know is always helpful. Make sure your mediation brief is strong, researched, and not too fluffy. What I mean by that is mediators, again, do this work often, right? They want to read your mediation brief. They want to have the facts. They want to see what you're asking and see what facts and case law support what you're asking for, right? Often clients feel in mediation that sometimes potentially some of their story is lost, and that can feel frustrating, especially if you've had something, happen in your relationship, or you felt as if your partner did something wrong to you. While I think some of those facts can sometimes be important, they're not always. And so I think you want to remember that your attorney is not forgetting your story or doesn't think it's important, but they're sticking to the key facts so they can get to a quicker settlement for you and your case. And this kind of all ties in. I wrote mediators care about feelings but want to know more about facts, and I think this tied into what I was talking about earlier. You know, you don't need to convince your mediator, but I think what clients often think is that it's me against the mediator, and really the mediator is on your side trying to work with the other side to make you guys come to an agreement. So work with your mediator, feel and be honest with them, and use them as an asset instead of using them or feel like they're working against you. I think that's one way you can really be successful in mediation. So if anyone has any questions, please let me know. But thank you so much. And if you are going into mediation, please reach out to a Beresford Booth family law attorney. Thanks so much.